we're now getting into the parts of the panel that I actually understand the law on, or at least I think I do, more so than AI. And really what we're talking about are the core challenges to 10J relief and developments in collective bargaining. So we're into the realm of the labor portion of this as opposed to the employment portion. We have a really good panel of people who I think are the right people to talk about this. Matthew Ginsberg, who's the general counsel of the AFL-CIO, long-term practitioner in the area, I think has a lot of insights in terms of what's happening in the labor movement and what's happening in terms of the legal issues surrounding it today. Peter Rawlings, who is a NYU 24, so I guess a third-year student, is a Florence Allen Scholar, the Arthur Garfield Hayes Civil Liberties Fellow, the executive editor of the NYU Law Review, and perhaps even more critical as a credential here, pre-law school was a journalist, and wearing that hat, was involved in organizing 2 newsrooms with the News Guild of New York. So we've gone from the abstract to the real world part of labor law, which is critical. The third panelist is somebody I've known probably 45, 50 years. It's Scary Paul Salvatore, who is one of the longtime leaders of the traditional labor practice and the labor and employment practice at Proskauer. Talking about the Supreme Court and its practices before Paul was the person who represented the employer before the court in 14 Penn Plaza v. Payette. I know so many people who said they worked on that with Paul because they wanted to tag themselves to it. It's really an important case. Trustee, graduate of Cornell Law School, trustee, fellow ILRI. And with that, I'll turn it over to this esteemed group and Sam.
Let me just interject for one moment. Matt Ginsberg is a former student, and I take credit for all my success stories and all my students for success stories. Matt took the course, the seminar in appellate advocacy with Larry Gold, the former general counsel of the AFL-CIO with me, and he was clearly the star of that seminar. Both Larry and I agreed. It's great to have him back here, just back and in the important position that he has with the American labor movement. One thing that was left out of Peter's credentials is he's my co-author, which is a very select company. We just did a piece on a very important 10J case, which we'll be talking about, that's in the Second Circuit. And he's written a very, very important piece on the issue. It's going to be published by the NYU Law Review? Or?
No, not as right now.
Not as right now. It's in formative stages. Anyway, Peter is another star. I don't know if he's a Matt Ginsberg, but it's something to aspire to. Okay. Who's the moderator, Paul? Paul, by the way, is one of the great leaders.
You're going to turn it over to me now, Sam?
Yes, right now. Paul is one of the leaders of our field.
All right. So welcome, everyone. We have a potpourri of labor topics to talk about, with the principal topic being Peter's 10J paper. And we'll get to that in 1 second. But we also want to talk about CEMEX, employee-athlete unionization, some challenges by SpaceX and others to the constitutionality of the National Labor Relations Act, the law that provides for us and our families, and the actions by some southern legislatures on impairing certain aspects of the National Labor Relations Act. And some blue state legislatures as well. So we'll try to rush through all of this and hopefully can cover it. Labor is certainly having a moment. There's no doubt about that, with our most pro-union president ever. And the question that I ponder is whether this moment will turn into momentum and we will see change. I think the November election, as we all know, will have a lot to do with labor's continuing success. But today our main focus is going to be on 10J. Let me give you a little background quickly, particularly for those that are not part of The traditional labor bar, Section 10J of the National Labor Relations Act, allows the board, the NLRB, to seek temporary injunctions in federal court while cases are being litigated in order to ensure that any remedy that the board can issue would not be moot or hollow. And in cases where an employer may have fired an employee in retaliation for union organizing efforts during a campaign, the board has used 10J injunctions to obtain the preliminary reinstatement of those employees. 10J has been around since the beginning of the act. In recent litigation, however, involving Starbucks, the company has responded to multiple board 10J petitions to preliminary restore fired union supporters by requesting extensive discovery. In particularly, Starbucks has subpoenaed numerous current and former employees seeking wide-ranging information about workers' views on the union campaign. Starbucks' argued rationale is that such information is necessary to counter the board's contention that the discharges chilled union organizing. Starbucks has argued that, quote, establishing 10J relief is just and proper, requires proof alleged unfair labor practices have a chilling effect on the organizing campaign. The discovery requests are meant to adduce evidence that would demonstrate, supposedly, that there had been no chilling effect on organizing, and therefore the requested injunctive relief was not necessary. So this is what I would call a chill causation theory for the basis of this discovery. On the other side of the argument, prolonged discovery is time-consuming, irrelevant, and undermines the board's ability to safeguard organizing campaigns. So Peter's paper takes on this very timely and meaty issue, and as he'll describe, he asserts that district courts should apply a rebuttable presumption precluding an employer from taking discovery concerning employees' subjective perceptions of union activity and the impact of the discharge. He goes on to say that there are circumstances where an employer could demonstrate the bases for the presumption are not operative in a given case, and that some limited discovery, would be appropriate. So I'm going to turn it over to Peter to introduce his paper, which is entitled "Limits on Employer Discovery in 10J Proceedings: The Starbucks Subpoenas and the Trouble with Employee Inquiry in Discharge Cases." Peter?
Oh, thank you. So yeah, what you've just described sets up the types of discovery requests that Starbucks has been making in a number of current 10J proceedings. My paper focused in particular on the discovery requests that seek information from employees concerning their subjective views on union organizing and their reasons for supporting or not supporting the union, which most of the discovery requests that have been made in these cases go to, although not all of them. I thought maybe I could just start by providing a few examples to make concrete what Starbucks is asking for. So in one recent 10J petition, they asked the district court to approve a discovery request that would oblige employees to turn over to them information concerning, for each employee of the relevant stores who has been or has considered at any time to have changed from being in favor of union representation to not being in favor of it, any statements the employee made or things that the employee did that factored into that determination. And if there are any, the employee's name. Starbucks has asked for all emails from the union's email address by any Starbucks employee that reflects interest in starting a union campaign at any Starbucks store, attending union meetings, participating in a union bargaining committee, or serving as a union representative, support for the union, or fear of retaliation, and all documents relating to and or discussing reasons other than the alleged retaliation that employees have cited as a reason for not supporting the union. So as you said, the theory that Starbucks has put forward for why it ought to be able to get this information from employees is a chill causation theory. I think that's a good way to describe it. when the board seeks 10J relief from the district court is going to look firstly at whether or not it thinks it's reasonably likely that the alleged unfair labor practice has occurred. Not importantly, the district court is not going to determine whether or not it has occurred, but just look at the evidence before it to decide if that seems likely. And then if it does seem likely, it will look at whether or not relief would be just and proper to issue. And the information that Starbucks has asked for is supposed to go to that second prong. The argument being essentially that even if we have fired these employees illegally in the way that the board says that we have, there's no need for you, district court, to preliminarily restore them to their job because there's been no chilling effect on any other employees at the Starbucks stores. So we need information from employees to show either that union support is as strong as ever, or to ask employees about if they have stopped supporting a union campaign, their reasons for that, because maybe the reason they stopped supporting the campaign has nothing to do with any illegal activity we might have engaged in. It's for other reasons entirely, such as union misrepresentations or just other factors. And that's the argument that Starbucks has made to the district court, that it needs this information to show that there's been no chilling effect, or if there has been any chilling effect, it's not their fault. And as I argue in my paper, I think that district courts should reject this argument for two chief reasons. The first being that I think that this is irrelevant information that Starbucks is seeking. And the reason for that is that there's a lot of board precedent and circuit court precedent that explains quite clearly, in my view, that when there's been a retaliatory firing of a union organizer, an employee, there's an inherent chilling effect in that illegal action. So there's no need to take discovery to try to figure out whether or not there's been a chilling effect in the way that Starbucks says that it needs to do. The board, going back to some of the earliest cases, following the passage of the NLRA, has explained that there's inevitably going to be a chilling effect on other employees' willingness to engage in Section 7 activity when an employee is fired in retaliation for organizing. And the circuit courts likewise, have repeatedly explained that there are certain types of hallmark violations of the act, like retaliatory discharges or plant closures or threats of job loss, that are just going to have a inhibitive effect on employees' future willingness to organize without any need to explore the matter further. If these violations have been committed, one understands, and it's, aside from the precedent, I think a pretty intuitive concept as well, that, when these types of violations are committed, other employees are going to be intimidated and not able to effectively exercise their rights under the act. So, as I say, going back to the way the district court evaluates these petitions, the information that Starbucks is seeking doesn't go to whether or not it has fired the employees illegally or not. It just goes to what the effects of that firing are. And if a district court can find or does find that it seems reasonably likely that the firing was illegal, there's no need to conduct discovery to figure out whether or not that illegal firing has had any chilling effect on other employees. It's well understood that it's inherently going to chill other employees. There might be other reasons for a district court to nevertheless deny a request for 10J relief, even having found that it's likely that a firing was illegal or that some violation of the act has occurred. But the absence of a chilling effect, I don't think is one of them, because of all of these prior decisions and the common sense intuition that when an employer fires an employee illegally, it's going to chill other employees. I think the other big concern with these discovery requests, and the other reason that district courts should view them with some skepticism and reject them to the extent that they're asking employees about their views on union organizing, is that the requests themselves are inherently kind of coercive and are themselves going to further chill employees' willingness to exercise their Section 7 rights. And again, I think, there's both precedent that supports this notion, as well as, I think, common sense that when an employer asks an employee to provide information or subpoenas an employee to get information concerning their views on a union campaign and their reasons for supporting or not supporting a union. That's going to intimidate the employee, given the power dynamics that inevitably exist in any workplace. And as I say, there's also a number of Supreme Court and Circuit Court cases that explain this principle quite well in other contexts. So, for instance, after the Freedom of Information Act was passed, there were a number of cases in which employers sought to get information from employees through FOIA, such as witness statements provided to the board in the course of investigations or union authorization cards. And the courts repeatedly rejected these requests for the reasons I just briefly described, that employees have a privacy and confidentiality interest in their subjective views about union campaigns and union organizing, and there's going to be a necessarily intimidating effect in the employer even asking the question. So for those two overarching reasons, the irrelevance of the requests in that they're seeking to dispute the chilling effect of an illegal firing that everyone understands is going to inevitably follow, and because the requests are themselves destructive of employees' Section 7 rights, I think that district courts should reject them to the extent that they are seeking employees' subjective views, and that the reasons I just gave are implicated. Nevertheless, some district courts have granted, to varying degrees, requests of this sort that Starbucks has made, and there was, circuit courts are now starting to review those decisions and take up the issue too. So maybe I'll
Well, that's
leave
a
it there
good
for now.
segue, I think, to what recently just happened. It came down last week or the week before. Leslie, right? Was it the
Right.
decision? You want to talk a little about that, because it seems like your theory is being, at least in some sense, maybe not by formally adopting a presumption, but by in practice kind of putting one into effect by the Second Circuit.
Sure. So the examples of the Starbucks discovery requests that I gave were from the Western District of New York District Court case in Leslie, which was, like many of these cases, a case in which the board alleged that Starbucks had fired an employee organizer illegally and sought 10J relief from the district court. And the judge in the district court in that case granted a large number, although not all, of the discovery requests that Starbucks made, seeking the types of information I described, much of which had to do with employees' subjective views of organizing. And there's a whole other kind of set of other cases related to that proceeding, in that the union refused to comply with the document request, and the board itself then brought a separate unfair labor practice proceeding against the employer. But in any case, after the district court approved a lot of the document requests, the Second Circuit took it up and has now vacated the district court's decision to grant the requests. I think for reasons somewhat similar to the relevance issues that I was just mentioning, that it doesn't seem like plausible that if Starbucks fired these employees illegally, that it can be any question that there's been a chilling effect on other employees. And so the Second Circuit there vacated the decision, and it looks like there's going to be some more fact-finding that the district court is going to be asked to do at the district level before coming to a determination about which, if any, of the requests to approve.
Yeah, I mean, the Second Circuit was very clear, page 16 of its opinion, that it rejects this chill causation theory that Starbucks is asserting, but still feels, I think, bound by the federal rules of civil procedure with respect to what the district court's supposed to do in evaluating whether the subpoena is overbroad, or whether the subpoena seeks applies is disproportional to under the discovery standard. So the kind of cabin by the procedural rules, it seems, and that's where they want the district judge to go. But I mean, as labor law practitioners, Matt, I mean, we kind of know that this is an area that, it's like a third rail, right?
Yeah. No, yeah, and so I just to back up just a half a step, I just want to say, like, this is a great presenters when you have a great paper that tees up the issue, and then the Second Circuit very conveniently issues its decision in a few days. So we should get that around, because I don't think it's in the materials. But I do think, to step back a half a step, and we're not talking about McKinney, which is the Starbucks case that's at the Supreme Court, but just to mention it, most of you probably know that case is at the court, and the question there is a real legal question about what is the proper standard for issuing 10J injunctions. Is it the standard that the Second Circuit uses, which is the two-part reasonable cause, just and proper standard, or is it something more akin to the traditional Winter four-part preliminary injunction standard? For those of you who, we will get a decision sometime in the next month, I would guess sooner rather than later, but if you've listened to the oral argument, I don't like to predict outcomes, but it didn't go well for the board, put it that way. And I think it is pretty likely we're going to get something more similar to what Starbucks has been asking for, which is the Winter standard, and I do think that is going to make all practitioners run to read Peter's paper, because there's going to be more. I think when you throw it back, oh, well, you should treat 10J injunctions like any other sort of injunctions, it's going to invite many more discovery requests, maybe not quite as extensive as what we've seen in the Starbucks litigation, particularly after the Second Circuit's views, but we are going to see more and more. So this is a really timely and important issue. So with that in mind, and with the Second Circuit sort of falling back on the federal rules of civil procedure, I really wanted to push on and I told Peter I was doing this, so don't think I'm being rude by pushing, push on his thesis a little bit, because I do think as practitioners, certainly on the labor side, we're going to need the strongest possible arguments to explain to district court judges who've just read McKinney, why is this sort of discovery inappropriate when, sometimes district court judges allow discovery on the preliminary injunction standards in other contexts. And so I like the subjectivity idea. I like the underpinnings of it, but I wonder, it's not all discovery requests are going to seek workers' subjective views. Some of it may be, and some of even the Starbucks requests might be more objective information, like who did you talk to? When did you talk to them? I wonder if it's something more akin to in the Rule 26 type balancing of thinking about, does this line of inquiry interfere with protected concerted activity? Is there something inherent about, because in these cases in general, where the interest is in protecting, putting fired workers back to work to protect protected concerted activity. So is that really what we're trying to get at? I'm not quite sure how we'd articulate that. And related to that, I wonder if there's some broad analog, and so management lawyers, don't throw things at me when I say this, to a sort of Johnny's Poultry type prophylactic rule, that the board itself places some protections when employers are questioning workers in the course of investigating an unfair labor practice case. That's Johnny's Poultry, or I think the new one is Sunbelt Rentals, same basic rule. Is that something, obviously a district court judge is not going to feel itself, his or herself bound by those same protections, but is that the sort of thing we're thinking about?
Yeah, that I actually had a large section in the original draft of my paper dealing with those cases, and took it out for the reason you could have just gestured at, which is that it seemed like maybe it would be less persuasive to district courts to come at them with a bunch of board precedent they wouldn't necessarily feel bound by. But I think that
Isn't there also a problem with relying on Johnny's Poultry? Because that's about employer unilateral questioning, and it's different here. When your court has approved the request for information, it's done under somewhat more structured, less. So I'm not sure there's an equal basis there, which I think is one reason for de-emphasizing. It's an analogy.
It's an analogy.
There are lots of analogies.
Yeah.
But I think the presumption works best, really, and maybe we should say not just mental perceptions, but also directly questioning the employee. There are other ways of finding out, what the union said. Ask the union what it said. Why you have to. So, I think that part is a good criticism. But There's a problem with relying on those cases. It's also true of the FOIA cases. You know, the reason we don't want that is because the employer is going to use it for some other nefarious purpose. Anyway, it's a hard question, and I've got to applaud the attorneys for Starbucks, because I've been in this field, you know, a long time. I know my youthful appearance derogates from that conclusion, but I've got to compliment the firm involved, because they are unbelievably creative. And they have created an issue that I didn't think existed, and that's why we need Peter Rawlings' teachings here. So I think the presumption works best. And I'd like Peter actually to emphasize it more. There are going to be cases where it's perfectly legitimate for the employer to argue that the chilling effect is highly unlikely, unlike the usual case. So if something happened in Buffalo, where my daughter happens to live, you know, and they want a nationwide injunction, I think the employer has a basis for challenging that. I don't know if you agree with me. I don't know if you need subjective inquiry, but it's a relevant issue whether there's a need for that nationwide injunction.
Mm-hmm.
So that's how I would frame it, but, you know, there's no reason to talk to the workers involved. I agree with that.
Well, I want to segue, if we can, just given the time. And maybe it's a good segue, because, you know, our clunky old statute is, you know, bumping into, you know, these new extreme stretched interpretations, you know, and that maybe are a product of a modern workplace, you know, when you have a almost 90-year-old law. And one area that I think has just received a facelift is our cases under the CEMEX, I'm told it's CEMEX, not CEMEX, decision, although I'll probably go back and forth. I mean, in the absence of congressional labor law reform for decades and decades, the NLRB here in CEMEX, in my view at least, took it upon itself to dramatically, in effect, amend the labor law in representational cases. We'll see if that holds up on appeal, because the case is up on appeal. I believe it's in the Ninth Circuit.
It is.
But in the meantime, employers are having to make the best of this. I mean, just for to bring everyone on the same page quickly, I mean, CEMEX holds that secret ballot elections are not the principal mechanism for union representation, and a minimal level of unfair labor practice activity by the employer could trigger a bargaining order, even if the union did not win the election. And a representation case under the new CEMEX regime, if a union makes a demand for voluntary recognition, the employer has 2 weeks to decide whether it will accept the union's demand based on recognition cards, and if accepted, then the employer would begin bargaining with the unit, or second, file its own petition with the NLRB because of a good faith doubt about the validity of recognition cards, or to challenge the unit. If filed, the employer and the union then would proceed through the standard representation process. This is derived in part from an old case, Joy Silk, which was much criticized, and that regime of Joy Silk was kind of put on the shelf many years ago, but it's come back in some way here, a different way. And the employer also, number 3, could ignore the request and wait and see whether the union files its own petition with the NLRB for an election. But that's a risky strategy, because under CEMEX, if no petition's filed, the employer risks being issued a remedial bargaining order if it refuses to bargain. And if a petition is filed, then obviously they would proceed through the representation process. So this is a far cry from the way things have worked for, you know, many years. CEMEX increases, you know, the likelihood that union representation will be ordered without employees exercising the right to cast a secret ballot vote, which has been called by the NLRB for many years the gold standard Combine this with the quickie election rules that the board has in place. I mean, there is a race to representation that is occurring in many, many workplaces. But, I mean, all this is still being worked out. The general counsel has issued some memorandum about it. The procedures are still being, tested by different parties in how they apply. There's actually some advantage under option 2 when the employer files a petition in terms of defining the unit and putting the union, in essence, to the test about who's in the unit, who should be in the unit, and the like. That's resulted in some interesting situations in practice, as well as defaulting away from the NLRB altogether into negotiating private election agreements, because both parties said enough. We're not interested in going under this regime. So a lot there, Matt.
Yeah, no, there is a lot there. And one of the interesting things about CEMEX is that it wasn't, I don't think any party asked for exactly this outcome. And so one of the results is that we have a real state of flux in this part of the law. There were a lot of folks asking to go back to Joyce Silk, which was the pre-Linden lumber rule. But the board instead came up with this sort of hybrid rule, which we're still trying to see what happens. I think the board, and maybe Chair McFerrin will have something to say on this, one of their real points was by creating this mechanism, it would lessen the likelihood of unfair labor practices in the representation regime. And I think I won't be surprised if a few years out, that is the primary outcome here. Not that we see more voluntary recognition, but rather that we see less unfair labor practices in the immediate run-up to an election. But we'll have to see. There is a lot to be still decided. The Ninth Circuit case the board filed its brief and argued in the alternative that the bargaining order could be affirmed on Gissel grounds. So we may not get any definitive ruling on CEMEX in the Ninth Circuit, so it may take quite a while till we see an answer. Yeah.
If I can interject for a
Yeah.
moment. I have a labor law casebook, which I'm glad former Chairwoman Liebman still uses. So I have actually read Gissel Packing in its entirety many, many times. And it's a very useful exercise. First of all, there's some very good language in there. It's helped Peter's thesis about not getting into why the employee signed the card and all that. But also, the court did not change Joyce Silk by a very important later case. It may have been a Republican board called Aaron Brothers, which said it had to be a substantial unfair labor practice. And I do fault the board for not having made that point clearly in its CEMEX decision. But the idea is, I mean,
Well, I've heard from some board members that actually that's really what they meant. So
It's
we'll
not
see.
clear. I
We'll
mean,
see what subsequent.
we don't inquire into subjective intention, says Peter. I'd like them to be clear about it, but it's
I
not.
just think one thing when you're talking about the standard, the level of unfair labor practice, is a recent GC memo that I think 2 weeks ago, where she kind of has tried to fill in that piece as to
Good.
what it means.
Good. So it's still a good law. I mean, I know you said it's, dead law, but it's still good law. And all the court said, again, this comes from reading these cases, not reading necessarily other people's briefs, but the court even in Linden Lumber said this is in the board's discretion. The Supreme Court said in Gissel Packing, it's in the board's discretion. So, and we know we have a problem with unfair labor practices that try to nip the campaign in the bud. 10J is a partial remedy. So I think if this doesn't done right, emphasizing it has to be an unusual case, I'm not sure all these cases involve substantial unfair labor practice, another issue. So I want you to qualify a little bit your ordinarily very careful language, Paul. I don't think it's necessarily Lazarus coming back. I do think it's a revival. It needs to be very clearly stated that it has to be a substantial unfair labor practice.
So another hot topic is the topic of We've got 6 minutes.
I wonder if we should go to SpaceX just because it flows.
Okay, yeah,
flows
let's
from-
let's
just 'cause
do
it
that.
flows
Let's do
from
that.
this.
Go ahead.
Yeah.
You wanna
Well, I was
start?
just gonna,
Yeah.
we're short of time, so one of the topics we wanted to touch on was the SpaceX case, which is the challenge, a variety of challenges to the board's constitutional underpinnings that SpaceX, who everybody knows is owned by Elon Musk, has brought in district court in Texas and has kept in district court in Texas for quite some time. I think this is a relevant segue because as Sam has just said, the board has lots of discretion, at least for the moment, to make up its mind about what the statute means. But the SpaceX case was really a shot across the bow from this big company about, you know, the board's continued constitutional authority, we'll see at the end of this term, to interpret what the statute means. So it raises, I think, implicitly a lot of Chevron issues and much more explicitly Seventh Amendment issues about remedies, which we thought were long ago
We were
settled.
discussing SEC versus JARCAS yesterday.
Right,
That's
which
the
I
case.
was hoping was going to come out this morning, but did not. So the ALJ's protection against removal, the double level of protection. So there's a whole slew of challenges. I'll just say more to come on that at the end of the term. But also there's a sub-theme here of the Fifth Circuit's very willful holding on to these cases, and it's not just NLRB cases, it's other federal agency cases where if you read the decisions, they've even managed to tick off a lot of the district court judges within the Fifth Circuit in terms of taking cases out of the district court into the courts of appeals. So there's a lot going on here that we'll continue to see in the next couple of
My
years.
colleague Cindy Estlin said this was an ossified area of the law. There's a
No,
lot
it's
happening, despite the ossification.
It is.
Anything more on?
I think
So I hate to do this because I could listen to this all day. And I wanted to hear the other topics that you didn't get to. I thought that the 10J stuff is really important, especially given having argued 10J on both sides and knowing that when you go into, you know, if you're there for the board, you're on behalf of the general counsel of the board, you're basically saying that you, the judge, don't have any discretion. You should just accept what the regional director said, as opposed to representing an employer saying, no, you need to look at this and you need to treat this like an injunction case, which I think is the instinct a lot of district court judges have. Some clarity on this, I think, will be helpful, or maybe it'll take away some of our creativity. But thank you all, this was really good. I can't wait to read the paper. I will send the panelists and Sam the GC memo from last week, which I think does shed some light on CEMEX. And thank you again.
Thank you.
Thank you.
Thanks.